Disposition Hearing. Come with me and let me tell you about the most important hearing in the juvenile dependency court system. Now, you may not have heard about the disposition hearing. That's because it's usually combined with the jurisdictional hearing. The jurisdictional and dispositional hearing is done together in almost 95% of the cases in California. There's a reason for that, and in my opinion, it's not an advantage to the parent. But I'm going to tell you about the dispositional hearing. The dispositional hearing is different from the jurisdictional hearing. You could lose the jurisdictional hearing, but still get your children back at the dispositional hearing. The reason is because there is a different standard and a different evidentiary test in order for the social worker to win the dispositional hearing. And a lot of people don't know that. Sometimes I get the impression that a lot of attorneys, even for the social workers and for the parents, don't understand the difference between a jurisdictional hearing and a dispositional hearing. I've even had the feeling sometimes hearing officers aren't quite sure of the difference. So let me tell you what a dispositional hearing is, the most important hearing. At the dispositional hearing, the social worker must prove two things by clear and convincing evidence. Now, you don't see that standard of burden of proof in the juvenile dependency court system very much, especially at the beginning of the case in what I call Module 1. The social worker must prove that you are a substantial danger, not just a danger, not just a risk, that you are a substantial danger to the child to keep the child out of your custody and in foster care. Now, that's pretty hard to do. I mean, you have to be one bad hombre or mother in order to keep the child out of your custody because you're a substantial danger. The second thing that the social worker must prove is that there must be no less restrictive alternatives other than placing the child in foster care. Now, if the social worker proves number one, that you are a substantial danger, and doesn't prove number two, the way I read the code is you should get your child back. So this is what happens in a lot of cases. I sometimes subpoena the person most knowledgeable in the department or in the social worker agency to come to court to tell us about alternatives to foster care. And I just did a case in Sonoma County not too long ago where the social worker came and told us all about many services that they have that are alternatives to placing the child in foster home. But you know what? The social worker on the case did not put those alternatives in her report, did not let the judge know that those alternatives were available. As a matter of fact, I had the feeling the judge was kind of surprised that there were so many services available with federal money that the social worker could give the family to keep the child with the parent. So there are two things: substantial danger by clear and convincing evidence, and by clear and convincing evidence, there's no less restrictive alternatives. Now you might say, well, Vince, what are the less restrictive alternatives? Let me tell you. What if you kept the child in the home with the parent and another relative moves in to watch and keep an eye on the parent? Most counties, if not all, have something called family preservation services. Each county may call it something different, but it's federal money that the county receives to keep your family together so your children don't have to go into foster care. You rarely see the social worker on the case talking about these services or even informing the judge about these services. So it's your job and your attorney's job to subpoena that social worker, that person most knowledgeable, into court so they can tell the judge all the alternatives there are so your child doesn't have to remain in foster care. You know, you're probably watching this video because you have questions. I answer questions like this every day from people that call me from all over the state of California, frankly, all over the country. If you have questions, please give me a call, 888-888-6582. That's 888-888-6582, and I'd be happy to answer your questions. Subscribe to our YouTube channel and press like on this video so that I can keep making these videos to help you in your CPS case.